We have the affidavit, not a summary of it, not a quote pulled from a news article. The actual sworn legal document that a Florida judge reviewed, line by line, and then signed, authorizing the arrest of Joseph Duggar on felony charges that carry a mandatory minimum of 25 years in prison and a maximum of life. And what is inside that document is not what most people covering this story have told you. Because this is not just a story about what Joseph Duggar allegedly did during a family vacation in 2020. This is a story about what law enforcement did in the days before his arrest, the strategy they used, the legal steps they took across 2 states, the specific Florida statute they leaned on to make sure that what Joseph said on a recorded phone call could never be thrown out of a courtroom. They planned this. They executed it. And Joseph Duggar, following a pattern that goes all the way back to how his family has handled these situations for decades, talked. He said 4 words that, under Florida law, directly satisfy the intent element required for a life felony conviction. 4 words that his own defense attorneys are now going to have to figure out how to explain away in front of a jury. 4 words spoken voluntarily, on a line he had every reason to know was being monitored. We are going to break down every single piece of this: the affidavit, the law, the pretext call strategy that law enforcement used and why it was so effective, the Jessica Lunsford Act, and what it means for Joseph's actual prison exposure, why a plea deal may not save him the way people assume it will, and something else. A woman named Amy Powell, connected to this same community, who made a decision that stands in direct contrast to everything the Duggar family has historically done when confronted with a confession. Before we get into it, this video covers detailed legal proceedings in an alleged child abuse case. We handle it factually and carefully throughout. Please know that going in. If you are new here, subscribe right now. This channel exists to give you the full legal picture, not just the headline. Drop a comment and tell us where in the world you are watching from. We have a community here from every corner of the globe, and every single one of you matters. To our subscribers, every person who shared the first video on this case, left a comment, sent it to someone who needed to see it. You made that video reach people it never would have reached otherwise. We do not take that for granted. Thank you. This one is for you, too. Now, let us start with the document that started everything. Most people covering this case have summarized the charges. Very few have actually read the arrest affidavit, the sworn legal document submitted by Bay County Deputy Sheriff Daryl Norris to a Florida judge to authorize Joseph Duggar's arrest. That document is now in hand, and it changes how this case needs to be understood. An arrest affidavit is not just a summary of what someone is accused of. It is a formal legal argument. It has to establish probable cause, meaning it has to convince a judge that there is sufficient evidence to believe a crime occurred and that this specific person committed it. A judge reviewed this document. A judge agreed it met that standard. And then a judge signed it. Here is what the affidavit establishes, step by step. Bay County investigators received the forensic interview conducted by Tontitown, Arkansas police. They did not just receive a summary. They watched the entire interview. They reviewed it in full. What appears in the affidavit is only the portion that directly satisfies the legal elements of probable cause for the specific charges being brought: the age of the victim, the nature of the contact, the location, the age of the accused. Everything that was needed to meet the legal threshold for a life felony under Florida law. After reviewing the forensic interview, Deputy Norris continued communication with the Tontitown detective. During that conversation, he learned that the victim's father had confronted Joseph directly on March 17, 2026, and that Joseph had admitted his actions during that confrontation. The affidavit then states, and this is the critical line, that, due to this admission, Deputy Norris requested the victim's father call Joseph again. That second call was recorded. On that call, Joseph admitted he had made contact with the victim over her clothing. He also stated that his intentions were not pure. That phrase, that his intentions were not pure, is not just a damaging personal admission. Under Florida law, it is the precise legal element that separates accidental contact from criminal conduct: intent. Joseph provided it himself, voluntarily, on a recorded line. A judge reviewed all of this, signed the arrest warrant, and the following morning, Joseph Duggar was in handcuffs. What law enforcement did here has a name. It is called a pretext call. And understanding what a pretext call is explains why this case is so much stronger than it might appear on the surface. A pretext call is a formal investigative technique in which law enforcement directs a witness, in this case the victim's father, to contact a suspect while investigators monitor and record the conversation. The goal is to get the suspect to repeat or expand on statements they have already made, in a setting that feels personal rather than official, while law enforcement captures everything. The technique is used specifically in cases where physical evidence is limited or absent, when an incident happened years ago, when there are no witnesses other than the victim, when a straightforward police interrogation might cause the suspect to stop talking. In those situations, a pretext call can be the difference between having evidence and having nothing. Deputy Norris knew Joseph had already admitted his actions to the victim's father the previous night. He had reasonable grounds to believe that Joseph, if called again by the father, would say the same things. So he directed the call. He monitored it. He had it recorded. Joseph answered. And he talked. This is not a coincidence. This is not luck. This is law enforcement executing a deliberate, documented, legally supervised investigative strategy. And it worked exactly as designed. Here is where the defense will almost certainly focus its first major legal attack, and it is worth understanding clearly because this is the argument that sounds strongest on the surface and falls apart when you look at the actual statute. Florida is a two-party consent state. That means, under standard Florida law, both parties to a phone call must consent to being recorded. Joseph Duggar did not consent to being recorded on that call. On its face, that sounds like the kind of thing that gets evidence thrown out. But Florida law also includes specific statutory exceptions, and those exceptions were written precisely for situations like this one. Florida Statute 934.032c states that it is lawful for a law enforcement officer or a person acting under the direction of a law enforcement officer to intercept a communication if they are a party to that communication and the purpose is to obtain evidence of a criminal act. The victim's father was acting under the direct instruction of Deputy Norris. The father was a party to the call. The purpose was to obtain evidence of a criminal act. Every element of that exception is satisfied. Florida Statute 934.032d provides a separate and additional exception, allowing a parent or guardian to record a conversation if they have reasonable grounds to believe it will capture a statement regarding an unlawful sexual assault against a child. The father had already heard Joseph admit to the conduct the night before. He had more than reasonable grounds. But Florida and Bay County did not stop there. Because this is an interstate case, the alleged crime occurred in Florida, but Joseph lives in Arkansas, law enforcement took a third step. They involved Tontitown, Arkansas detectives in monitoring the call. Why? Because Arkansas is a one-party consent state, which adds another layer of legal protection. And because having Arkansas law enforcement present during the monitoring ensures the recording meets what is legally known as the color of law exception required by Florida courts. They covered every angle. They closed every door. The likelihood that a defense motion to suppress this recording succeeds is very low. Not zero. Defense attorneys will file that motion because they have to. But the legal foundation underneath this recording has 3 separate layers of statutory protection and documented law enforcement involvement. A judge will have to work very hard to find a reason to throw it out. This is the part of the case that most coverage has not fully explained, and it is the part that matters most for understanding what Joseph Duggar is actually facing. In 2005, the state of Florida passed the Jessica Lunsford Act. The law is named after Jessica Lunsford, a 9-year-old Florida girl who was abducted from her home, assaulted, and murdered by a convicted sex offender in 2005. Her case changed Florida law permanently. The Jessica Lunsford Act did several specific things. First, it drew a hard legal line at age 12. Under Florida law, any person 18 years of age or older who commits lewd or lascivious molestation against a child under 12 commits a life felony. Not a standard felony, a life felony. The law does not grade this offense based on what specifically was done. It does not matter whether the contact was over or under clothing. It does not matter whether it was brief or extended. What matters is the age of the victim and the age of the accused. That is it. Florida drew that line in 2005 and has kept it there. Second, the Jessica Lunsford Act removed judicial discretion. A Florida judge in a case meeting these criteria cannot give a sentence below 25 years. That is the mandatory minimum floor. The judge has no authority to go lower, regardless of any other factor in the case. Third, Florida law does not allow certain defenses that other states permit. A first offense is not a mitigating factor in Florida for this category of crime. A lack of prior criminal history is not a mitigating factor. The accused's own history of being abused as a child is not a mitigating factor. Ignorance of the victim's age is not a defense. None of these arguments can be raised to reduce a sentence. What does matter under Florida law is intent. The prosecution must establish that the contact was not accidental or incidental, that it was deliberate, and that the accused intended it for their own purpose. Joseph provided that element himself when he said his intentions were not pure. Under the Jessica Lunsford Act, that admission directly satisfies the intent requirement. In 2025, Florida strengthened these laws further. Mandatory minimums were increased. Most forms of early release for this category of offense were eliminated. The 2025 updates apply to cases prosecuted now, which means the version of Florida law that Joseph faces today is stricter than what existed when the alleged conduct occurred. It is worth being precise here. The charges against Joseph are being prosecuted under the law as it existed in 2020, when the conduct allegedly occurred. The life felony classification was in place in 2020. It was in place then. It has not changed. Anyone suggesting this was not a life felony in 2020 is incorrect. The previous coverage of this case has treated Joseph's Florida charges as a single category. They are not. He faces 2 separate charges with 2 separate sentencing structures, and a judge has the authority to run those sentences back to back. Count 1. Lewd and lascivious molestation of a victim less than 12 years old by a person 18 years or older. This is a life felony under Florida law. Mandatory minimum of 25 years, maximum of life in prison. No judicial discretion to go lower. Count 2. Lewd and lascivious behavior conducted by a person 18 years or older. This is a second-degree felony. Maximum sentence of 15 years in prison. If convicted on both counts, A judge can order those sentences to run consecutively, meaning back-to-back, not simultaneously. That means the theoretical maximum exposure Joseph faces, if convicted on both counts with consecutive sentencing, is a mandatory minimum of 25 years on count 1, plus up to 15 years on count 2. At 31 years old, Joseph Duggar is looking at the realistic possibility of spending the rest of his life in prison. A lot of people looking at this case assume a plea deal is the most likely outcome. And in most criminal cases, that assumption is reasonable. Plea deals are common. They resolve the majority of criminal cases before trial. But the Jessica Lunsford Act significantly limits what a plea deal can actually accomplish in Florida for this category of offense. Here is the legal reality. A prosecutor can offer Joseph a deal, but a Florida judge is legally prohibited from sentencing below 25 years on a life felony involving a victim under 12. The judge has no discretion. The floor is the floor. So even if the prosecutor agrees to recommend a lighter sentence, the judge cannot go below 25 years unless the charge itself is reduced to a different crime entirely, one that does not carry that minimum. That is the only path to a sentence below 25 years. The prosecutor would have to agree to drop the life felony charge down to a different offense. And here is where the practical reality of this specific case creates another obstacle. Bay County officials have already publicly labeled this a high-profile case. There is significant national attention on how this prosecution is handled. If Bay County prosecutors agree to reduce a life felony charge for a nationally known defendant with a documented recorded admission, the political and public backlash would be immediate and significant. It would look like exactly what it would be: a celebrity getting special treatment. That does not mean a plea deal is impossible. It means the room to negotiate is considerably smaller than in a typical case, and it means whatever deal might be offered, it almost certainly does not involve Joseph walking away with less than 25 years. There is a pattern in this family that needs to be named directly, and it goes beyond a pattern in the Duggar household specifically. It is a documented pattern of how both Josh and Joseph handled confrontations with law enforcement, and why, in both cases, their own words became the most damaging evidence against them. When federal agents executed a search warrant at Josh Duggar's car dealership in 2019, they arrived without explaining to Josh why they were there. Before they said anything, Josh asked whether someone had been downloading child pornography. Not whether something had been stolen. Not whether there was a legal issue with the business. His first question was specifically about child pornography. During the interview that followed, Josh asked investigators multiple times whether material had been uploaded or downloaded and how it had been identified. He asked about the IP routing system used to trace the activity. He said, and this is documented in court records, "I don't want to say that I'm not guilty. I don't want to say anything that could possibly be used against me." His defense later argued his statements were inadmissible because they were not recorded. That argument was rejected because two investigators were present. Both testified under oath that Josh made those statements, and their investigative notes documented the conversation. Now look at Joseph. A father calls him. A detective is on the line. Joseph answers the phone and says his intentions were not pure. Two brothers, two different investigations, two different sets of charges, the same result. Their own words, spoken voluntarily, became the primary evidence against them. The reason this pattern exists is worth stating clearly. For years, the Duggar family's internal response to wrongdoing has followed a specific script: confess, apologize, pray, move on. That framework has been documented publicly in multiple accounts of how the family handled Josh's conduct as a teenager. It is a cultural and religious reflex. Acknowledge what you did, express remorse, seek forgiveness, and trust that the confession and the apology are the end of the matter. What that framework does not account for is the legal consequence of making admissions to someone who is being directed by law enforcement. What felt like a private, personal, spiritually appropriate response to the victim's father, acknowledging what he had done, saying he was sorry, saying his intentions were wrong, is now a documented, recorded, judicially authorized piece of evidence in a Florida criminal case. Jim Bob Duggar spent years telling the people in his family and his community that confession and apology were sufficient. In the state of Florida, in a courtroom, they are not the end of the matter. They are the beginning of it. If this breakdown is giving you legal context you are not getting anywhere else, subscribe. Turn on notifications. Drop a comment below with your thoughts on what Florida law means for this case. We read every comment, and this conversation matters. We will be here every time this case moves. There is a name that has not been in any major coverage of this case and needs to be. Amy Powell is the mother-in-law of a man named Carver Bowers. Carver Bowers was a friend within the Duggar community, connected to the same extended circle of families that orbit Jim Bob Duggar's world. Carver Bowers was facing similar criminal charges in the state of Alabama. Amy Powell went public. She stated that Carver Bowers had confessed to her about what he had done, and she made a decision that runs directly counter to everything the Duggar family has historically done when confronted with this kind of confession. She turned him in. She contacted law enforcement herself. She decided that a private confession and a personal apology were not sufficient. That accountability required something more than silence. Her decision sent a significant message through the extended Duggar community, a community in which loyalty to family and church leadership has historically taken precedence over external accountability. What Amy Powell did was choose the victim over the community. She chose law over deference. She chose to use her voice when the cultural pressure was to stay quiet. Her full account is available on her own YouTube channel for those who want the complete picture from her directly. The contrast with Jim Bob and Michelle Duggar's response to Joseph's arrest could not be sharper. Michelle Duggar bailed Kendra out of jail. She confronted a journalist on a public road. She said she was protecting children. Jim Bob has said nothing publicly. No statement, no condemnation, no acknowledgement of the victim. Amy Powell had less institutional power, less public profile, and less family loyalty to protect than Jim Bob and Michelle Duggar. She still made the call. She still turned someone in. She still chose accountability. That choice is now part of the public record of this case and this community. One of the most important facts in this case is one that rarely gets explained. The alleged conduct occurred in Florida. Joseph lives in Arkansas. And the difference between those two states, in terms of how they handle this category of crime, is enormous. In Arkansas, the same alleged conduct would likely be prosecuted as sexual assault in the second degree, a Class B felony, carrying a maximum of 20 years in prison, with mitigating factors permitted. Until recently, Arkansas law allowed individuals convicted of this type of offense to be eligible for parole after serving only 1/6 of their sentence. Under that system, a person sentenced to 10 years could potentially be released after less than 2 years. Arkansas also allows judges to consider mitigating factors: first offense status, lack of criminal history, personal circumstances, when determining sentences. The outcome in Arkansas would look very different from what Joseph faces in Florida. Florida has none of those allowances, no mitigating factors, no early parole eligibility for this category of offense under the 2025 updates, no judicial discretion to go below 25 years, a mandatory minimum floor with no exit. The conduct allegedly occurred in Panama City Beach, Florida, in 2020. That geographic fact, where the vacation house was located, which county it fell in, determines which state's law applies. And that geographic fact means Joseph Duggar is facing a Florida courtroom, Florida law, the Jessica Lunsford Act, and a mandatory minimum that did not exist in the state where he lives. As of the latest confirmed reporting, here is the full picture. Joseph Duggar has signed his extradition waiver. He is still being held at the Washington County Detention Center in Arkansas. Bay County, Florida, has until approximately April 19th to transfer him. Once he arrives in Florida, a bond hearing will determine whether he is released before trial. Given the severity of the life felony charges and the documented admission on record, a high bond, or no bond at all, is the most likely outcome. In Arkansas, both Joseph and Kendra face 8 misdemeanor charges each, 4 counts of second-degree child endangerment and 4 counts of second-degree false imprisonment. Their Arkansas court date is April 29th at Elm Springs District Court. Each charge carries a maximum of 1 year, meaning each faces a theoretical maximum of 8 years on the Arkansas charges. Kendra Duggar remains out of custody on $1,470 bond. Her mother-in-law, Michelle Duggar, paid that bond on the day of Kendra's arrest. The Tontitown Police Department has confirmed the investigation in both states remains active. No defense attorney has been publicly confirmed for Joseph or Kendra in either jurisdiction as of this reporting. Jim Bob and Michelle Duggar have issued no public statement about the charges against their son. Their only documented public action in connection with this case is Michelle bailing Kendra out of jail and confronting a journalist outside the family compound. Joseph's sister Ginger Duggar Vuolo said on her podcast on March 25th that the week had felt like years and that she did not think her heart could break the way it has. Her husband, Jeremy Vuolo, called the victim brave for coming forward. They were the second family members to speak publicly after Jill Duggar Dillard and Derek Dillard issued their statement on March 19th. Josh Duggar, through his attorney, called the allegations against Joseph a false accusation. He remains at FCI Segoville in Texas. His current motion to vacate his own conviction is pending, with no hearing date confirmed. Here is what the affidavit tells us when you read it straight. Law enforcement in 2 states coordinated a legally documented investigative strategy. They obtained a forensic interview. They reviewed it in full. They identified that a prior admission had been made. They set up a monitored, recorded pretext call using a father as the contact. They covered the 2-party consent issue with 3 separate layers of statutory protection. They involved Arkansas detectives at the request of a Florida investigator, specifically to close every legal loophole. A Florida judge reviewed all of it and signed the arrest warrant. This was not a casual investigation. This was not a rush to make an arrest. This was a deliberate, documented, legally supervised process executed specifically to ensure that whatever Joseph said could not later be thrown out of court. And Joseph talked. He said his intentions were not pure. In a state where intent is the deciding legal element, in a state where that admission alone satisfies the probable cause requirement for a life felony, in a state where the mandatory minimum is 25 years and a judge cannot go lower, Joseph Duggar has not been convicted. He is legally presumed innocent until proven guilty. The legal process ahead will determine what a Florida court decides about the evidence. But the affidavit is signed. The recording exists. The admission is documented. Deputy Daryl Norris did his job. The Tontitown detectives did their job. The forensic interview team did their job. The victim came forward, told the truth, and the system, this time, moved. This case is not finished. We will be here every time it moves.